Welcome back to the Corpora podcast, where I sit down with leading professionals and thinkers to talk all things startup law, entrepreneurship, and technology. Corpora is an all-in-one platform for startups to get legal done. Simple enough for founders, robust enough for counsel. Whether it's keeping your house in order, making sure that you are all safe on the legal side, asking questions about startup law, or getting a document drafted, Corpora has you covered. Check us out at corpora.us. It's free to sign up. My name is Stepan Khazretian. I'm the co-founder and CEO of Corpora, and I'm thrilled to introduce our guest for today, a good friend of mine who also went from being an exceptional lawyer to a founder in the legal tech space. His name is Ryan Samii, and he's the founder of Standard Draft, and I have the pleasure of reading out his impressive bio. Ryan is the founder of Standard Draft, a contract tech startup. Standard Draft is designed to accelerate the process of reaching agreement through a combination of world-class, highly configurable contract forms, and a two-sided platform for modular drafting and negotiating. Ryan was born and raised in Los Angeles. He studied economics and political science at UCLA and received his JD from the University of Michigan Law School. After his chapter in Ann Arbor, Ryan returned to LA, where he began his corporate legal career at Paul Hastings. Ryan practiced in M&A and Emerging Growth, assisting clients throughout their life cycles, from early-stage financings to M&A exits, amounting to dozens of billions of dollars of transactional value. Feeling the entrepreneurial itch and seeing a meaningful problem that seemed solvable, Ryan took the leap of faith to start building Standard Draft. And that brings us to our conversation today. Ryan, so great to have you.
Fantastic. Absolute pleasure to be here. Thank you for reading out the bio and excited for the conversation we're about to get into today. Let's go for it.
Let's do it. Thank you so much for agreeing to be here. And, we have a lot of ground to cover. You've been on this amazing journey through law school, the practice of law, into legal tech. But let's take a step back and talk about Standard Draft. For those in our audience who are maybe unfamiliar with Standard Draft, what is it that you do?
Yeah, happy to dive right in. So maybe before I talk about Standard Draft as the solution, let me talk about the problem that it is I hope to solve. And it all comes down to this fundamental process of reaching agreement. This is a process that is critical when you're starting a business, when you're growing a business, when you're partnering with other businesses. It is very much the lifeblood of what it means to start and grow a company. And I think you and I, as former corporate lawyers, we had a certain kind of perspective into that process of reaching agreement. And most of our work went into contracts, the core building block around that process of reaching agreement. And what I found through my legal practice is the drafting and negotiation of contracts, this critical step of the journey for many companies as they are going through their life cycles, is extremely inefficient. The friction when it comes to putting a contract together, negotiating it with a counterparty, was something that I thought could become a lot more streamlined. So the Standard Draft story is all about accelerating the process of reaching agreement. And the way that we do that is we are putting together world-class, highly configurable contract forms. You can think about that as the content side of our business, with a two-sided platform for more of a structured and modular approach to drafting and negotiating. Now, what does that all mean in practice? Well, instead of you and I leaving this room today needing an NDA or a master services agreement or an asset purchase agreement and going through that normal process of debating which side's form to use, going into that ping pong of drafts back and forth, Standard Draft now represents this middle road where we can agree to use this world-class baseline contract form. And instead of focusing on the wordsmithing and issue spotting of the normal contract process, we can instead focus on resolution and negotiation at the key point level. So that is what I'm excited to build and what we've brought to market.
Ryan, to put this into perspective, you mentioned that you're building something akin to the Y Combinator safe. You're starting off with NDA. So when you say a world-class contract sample, just like the name implies, Standard Draft, you're building that standard draft of the NDA, which various parties, buy side, sell side, will be aware of, and they'll know what they're starting off on. And they'll sort of focus instead on the strategic matters as opposed to the nitty-gritty words you mentioned.
That's exactly right. And I know with what you're building in your audience, I have a feeling that people are familiar with certain existing forms of standardized contracts. The Y Combinator safe is a pretty common one in the venture ecosystem, as are what are known as the NVCA or National Venture Capital Association docs. And you'll every now and again find some other cottage industries and transactions where there are comparable standardized forms. but they're largely the exception to the rule. As you and I know from our legal careers, for most contracts out there at the B2B level or in the complex deal-making space, whether it's M&A or anything else, you don't have those standardized contracts that the ecosystem has rallied around. So instead, you have this really bespoke workflow. And the standard draft view, and something that I was fortunate to see in my years of practice, focusing both on M&A, where we didn't quite have those kinds of standardized forms, and then on the emerging growth venture side, where we did have those standardized forms, was the opportunity for that. So what we hope our NDA, our initial wedge product, can someday represent is that sensible, reasonable baseline. You and I should no longer have to go through this process of me reviewing your side's NDA or you reviewing my side's. How about we start from this understood baseline, and now we're focusing on those key touch points of our negotiation in much the same way people operate right now with existing standardized contracts like the YC Safe. Now, the interesting challenge here, and where I continue to get excited in this endeavor, is you don't just snap your finger and say something is a standard. That comes with time. That comes with effort. And for us, we think that's going to come with what we're doing on the technology side as well, where we're not just creating these contract forms. We are wrapping them up in this robust tool to draft and negotiate in a highly structured and accelerated manner. And we think these two things, what we're doing on the content side and on the technology side, is what can lead to something really profound.
That makes a ton of sense. Ryan, you went to a superb law school. You studied for 3 years. You took arguably the most grueling bar exam on the planet. You made a comfortable living as a lawyer. And then apparently you left all that behind and you made a leap into uncharted, unknown waters of legal tech. Please make that make sense.
Can we extend this podcast to a 6-hour episode? Listen, I wish I could say as simple as waking up one day and having this eureka moment and just knowing that was the path. It's never quite that simple. I think what ended up making a really big difference for me, given all the things you just explained, sort of the road it took for me to get to where I was, and as I was beginning to think about the risk that could come next, was that the very problem I wanted to solve was the problem I was interacting with day in and day out. So there was no kind of separation here where I had some idea about a product I wanted to build or a company I wanted to start, and I was able to lock that away somewhere in my brain where I was just thinking about it during my free time. Day to day, as an M&A lawyer, I was seeing the opportunity because I was spending those hours, those long nights, those early mornings, kind of playing this game over and over again around drafting and negotiation of complex contracts. And so it just got to a point where I was seeing more, I was communicating with colleagues, with clients, and I was just gaining more and more conviction that there was a problem, A, and that B, there was perhaps a solution that could be built. So for me, it was the kind of repetition of activity, the domain that I was starting to gain some expertise in, that just pushed me more and more towards wanting to build this solution. So there's certainly that aspect of it. I think too, I have always had somewhat of an entrepreneurial itch, and as someone that went straight through to law school from undergrad, and that sort of that being sort of the only career I had seen, I just felt this urge for the next adventure. And that's really how I described it to a lot of the people that I was working with when they wanted to learn a little bit more about why it is that I was thinking about making this sort of leap, is it just felt like it was time for the next adventure. And so gaining conviction in the idea, just having that sort of drive to do something else was what pushed me. But we are lawyers. We are risk averse. We like thinking through things very analytically, and there was certainly some of that I had to do as well, of just coming to terms with the opportunity that was in front of me in a certain career path, the opportunity that I thought existed, taking a bit more risk, and how that could all shake out no matter what way my path transpired. So all of this together is what ultimately helped me make that decision.
Yeah, that, it's very powerful when a founder makes this leap, especially from a conservative field like law into tech, based on a personal pain, one that you've seen over and over again through the years, because that really allows you to delve into the details of that pain, get exceptional domain expertise in it and insight, and then that remaining piece is the entrepreneurial itch that you mentioned, that you feel very angry if I can put it that way, very frustrated that you have to deal with all that. That you took the bar exam, but you have to deal with all that drudgery that feels so unfair and so wrong, that you finally decide to make the leap and build technology that not only you can use, because you're essentially building technology that you wish you had yourself, but that others can use as well. And that's what drives this forward. You have two options, right? As a lawyer, either adopt technology that others build for people like you, or alternatively be one of the leaders and make that jump, that leap of faith, as you mentioned in your bio, in order to build the technology that others will use. Kudos to you for making that jump, man.
Yeah, no, I think it's spot on. You almost have to live with the problem.
Mm-hmm.
You have to understand it at such a deep level if you have any shot of coming out of that to build a perhaps simple and elegant solution. And that's one of the most interesting things I found in this new rodeo as a founder. A lot of the simple, intuitive, obvious solutions that we interact with on a day-to-day basis, whether it's hardware or software, the only way that those teams had any shot of making that as simple as it might feel to us now is because they understood the absolute depths of complexity of that problem to then come out the other end and build a simple and elegant solution. So I think just getting into that wrestling match with the problem is what takes you there. Now, I think that can manifest in different ways. I think there are probably a lot of lawyers who had the experience of, well, of course, what I do day to day should be more efficient. And they have found really profound ways of bringing that efficiency into their own practice. So it's not necessarily that you have to take a leap and start a company, start a startup. I think for me, it was that backdrop and then also seeing the particular opportunity with what I wanted to do. But I know obviously you navigated a similar path. Would you say it's largely the same story for you, or are there other aspects for your decision?
Yeah, no, it's very similar. I was practicing corporate law for over 10 years, and time again, I noticed that inefficiencies in the way law is being handled, especially with price rounds. The way I put it is price rounds are the amalgamation, the culmination of everything that is wrong and broken with startup law. All the inefficiencies surface during a price round, all the legal gaps surface in a price round. And so that price round setting is where you see how much time is being spent on organizing documents, how much time is being spent on correcting footers, chasing signatures, merging PDFs, conforming dates, filing things, all of which can be automated and simplified. And that was a tipping point for me. It goes back to a price round I did in April 2021. I'd been thinking about legal tech for at least 4 or 5 years before this, sort of surveying the field, putting my finger on the pulse, keeping my finger on the pulse rather. But that tipping point was this price round where I'm hired on Monday to take care of this round. On Tuesday, about 4 years of unorganized legal paperwork is dumped into my inbox. And on Wednesday, I kid you not, I get a text message. Do you think we're going to close this round by Friday? Like, what? No, of course not. And this really got me thinking. I mean, eventually we did close a month later, several hundred billable hours later, very many such text messages later. But when you really feel that pain, and you notice that pain is being related to by the founder themselves as well, it's like there's a problem here that can be resolved through a coalition building exercise where the founder and the council can come together, work together to make this magic happen. And so that was a tipping point. And fast forward 2 years, we set up Corpora, and now we're building the technology that I wish I had when I was a practicing lawyer. Definitely comes from that personal pain.
I think, the version of the two of us that are in this room having this conversation a year ago, 2 years ago, where we're probably both banging our head against the wall saying it should be better.
Yeah.
And here we are now trying to build the tools to make it better. So yeah, I think you and I followed a very similar journey in that regard.
True.
Right.
Let's switch gears to selling, Ryan. And that's maybe a point of difference between Standard Draft and Corpora. We don't sell to lawyers directly. We sell to startups. You do sell to lawyers and legal professionals. And so I hear selling to lawyers is tough from peers, from you as well. Why do you think that's the case? And how do you navigate this territory of selling to lawyers who are generally, just like you mentioned, risk averse? There are tried and true ways of doing things. You want to make sure that your document holds water in court. How do you get them to change their behavior and adopt legal technology?
Selling into a law firm, I think the classic framework you hear for this as to why it's challenging is the billable hour model. When you have an industry that's selling their services based on the time it takes to perform those services, you will have some perverse incentives. If something that traditionally takes 8 hours, you are now telling them, hey, we can give you some tooling to turn this 8-hour process into 1 hour. What's the incentive story there exactly? Why are they interested in that? And then even at a more practical level, when you and I were junior lawyers, chances are we wanted to kind of get into the craft and demonstrate our value to the more senior people we were working with by showing them all the edits we made in the contract, showing them all the issues we flagged and things like that. So I think just kind of the incentive system, both within the structure and sort of the incentive system around the pricing model, makes it difficult to propose making things more efficient, to propose having software tooling that could take up some of the job of what that junior used to do. And then you're wondering, well, what should that junior associate now do instead, right? Now, that being said, clearly the legal industry has evolved. If the story was as simple as, well, they have the billable hours, so they never want to be efficient, then they would presumably still be using, paper and quill, and they would never have adopted word processing. It's not that simple, right?
Mm-hmm.
So law has evolved. And the way that I think about this, and what I continue to think is probably the best avenue for legal tech startups, is to understand how it is that change occurs in the industry. And I have often seen that the change comes from, or the change is encouraged by the end users of the legal services, the clients.
The clients.
If the clients are demanding for something to be done more efficiently, well, now everything that we just have been talking about looks and feels a lot differently, because at the end of the day, it's a services business and you're trying to serve that client. And I think I've probably told you this story before. I remember when I was starting my legal career, DocuSign was a household name, and yet a lot of big law firms still hadn't adopted it. The prospect of going and using this cloud service, the idea of relinquishing some control over the signature process, which is that really critical step at that in the transactional journey. I remember people had a tough time with that. Until when? Until we got to a stage where the clients we were serving, we would send them, signature pages at 10 p.m. at night. And the answer is, you want me to print this? I don't have a printer. What are you talking about? The whole world uses DocuSign. Send me a DocuSign. And then we sent them a DocuSign, right?
Mm-hmm.
So I do think kind of finding the right stakeholders and evangelists on the client side is one effective avenue of inspiring change, not just maybe at the in-house legal level, but then bringing that to the law firm side as well.
Mm-hmm. Mm-hmm. Excellent remarks there. Very deep dive and giving context to the history of this problem. I think it should be a coalition building exercise. I think it's important for the end user, the client, to put that pressure on the law firm. But very often clients themselves are reluctant to be innovative in the space because they're not, just like the lawyer, they too see that the old way of doing things is tried and true, and they don't want to be the martyr, if I may, of legal tech. But instead, if they also in tandem get validation from the law firm that is willing to probably test the waters, be one of those harbingers of the change, and in tandem work to roll out legal tech, that's a winning solution right there. You mentioned the pressure from the clients. I want to add 2 other pressures here, Ryan. Number 2 is the pressure from within the law firm by the junior associates or the associates who feel frustrated, just like you and I did, of why are we doing this manually, and start putting pressure on the higher ups of, you know what, we can automate this. This need not be done. I didn't go to law school. I didn't take the bar exam to push this paper. Can also be a very effective way of building that coalition. And number 3, the competitive pressure that certain law firms will feel from their peers that are more progressive and forward thinking in terms of adopting legal technology. Those 3 working in tandem, along maybe with a little bit of thawing in government regulations of the practice of law will also help, is the winning solution of better legal tech adoption and maturity in this space. The billable hour still seems to be the main roadblock. My hypothesis, and the reason why we're starting with startup like Corpora, is that there are pockets in the practice of law which the billable hour isn't best suited for. Startup law is one of them. So in tandem with what I just mentioned, along with building that coalition, we're also advocating for a new way of billing clients, not the billable hour, but possibly the flat fee, the monthly subscription. And that's true not only for the boutique law firms, which are very flexible with billing, but the big law firms as well. So all of the above, the client pressure, the pressure from associates, the pressure from a competition, government thawing regulations, and rethinking building structures in certain cases is what it takes. It's all it takes, right, to make this change. It should be a concerted effort among legal tech companies to bring upon this change, but this is just some of my thinking of what the roadblock is and how we're going to overcome it together. You mentioned go-to-market, Ryan, and building startups is an exercise in constant iteration, right? On all aspects. Communicating, pitching, building your team, polishing your team and your product, and go to market as well. Thinking about your ideal customer profile, very high level. How do you think about go to market, both for legal tech generally, but also standard draft specifically? Any tips you'd like to share with our audience? What worked, what didn't work, what made you rethink? Because again, it's a very iterative process, right?
Yeah, I would say probably one of the bigger lessons I've learned so far in the journey is whenever you think you have identified your customer, your ICP, ideal customer persona, really force yourself to go 10 levels deeper, right? You might think that you've gone pretty specific already. So you and I in this conversation, we've thought about lawyers broadly, then we've thought about lawyers in-house versus lawyers in law firms. And so if you think, well, I'm going to build a product to serve in-house lawyers, you might think, oh, that's pretty specific. That's not nearly specific enough. You honestly have to go so much deeper than that, where as you compare what a commercial lawyer who's dealing with contracts in more of a B2B setting with counterparties who might not even be lawyers, their problem set and the kind of solutions that are going to be, compelling to them are very different than the in-house lawyer who maybe came from big law, and what they're working on now are really sophisticated, complex transactions that take weeks and months to negotiate and consummate. So that's what I mean. That's what I mean when I say you've got to go deeper. You can't just say in-house lawyers. Like you've got to find it. And I think one framework I came across recently that I liked for this, just as a thought exercise, is you have gone deep enough when you can write a sentence or two about your ideal customer persona and find an outreach or marketing person on Upwork who within a matter of 5 minutes could surface a list of 50 people for you from LinkedIn or something like that. The point being, the people that you and I might find on Upwork or anywhere else, they're not masters of the legal industry. So if we were to kind of be sort of broad and general about it, that would be tough. You've got to be so specific that this person with a few effective searches could find that list for you, right? And that's one thing you just sometimes have to learn through doing. I don't think any of this advice are things that you and I didn't know probably coming into our respective adventures. The idea of how important distribution is, you have to be really specific with your ideal customer persona. You understand the gravity of that once you really start doing. So I think that's probably been one of the bigger learning lessons up to this point.
Ryan, both of us are lawyers turned founders. It's a very difficult journey. We're essentially unlearning some of the things that we picked up in law school, passing the bar and working as a lawyer. We mentioned being risk averse, being very traditional, conventional, so forth. And we're learning new tricks, right? It's a very steep learning curve. We become jacks of all trades. I edit podcasts. You use Canva to do your pitch deck. So do I. We do a lot of things. And I'm sure in our audience, there are a lot of people just like us, 2 years ago. They're lawyers who are thinking about entering the legal tech space and becoming founders. What are your tips? What's your advice to them to take into account as they ponder this shift? And if they've already made that shift, what to think about as they go about the journey?
Yeah. So I think in both that pondering time frame and maybe the post-pondering time frame, you just have to have an honest conversation with yourself as to what your comfort level is going to be with risk, which I think is a different sort of prospect for, I think, someone who has trained as a lawyer, and how flexible you're willing to be to act on things that you just have no mastery over, but by virtue of being a founder of a startup, you just need to find a way to act. You almost constantly need to be in motion, experimenting, iterating, even before you can feel any level of confidence that you have a mastery over what you're acting upon, right? And so you and I as corporate lawyers probably knew enough to be dangerous when it came to intellectual property, when it came to, the regulatory matters that our clients were navigating. But we probably weren't so comfortable that we could just own that part of a representation and demonstrate to a client of like, oh yeah, I can totally do this for you. That is what you and I now do day in and day out in our current role. And so whether it's you're thinking about the right business model, the right sales motion, the right way to build your website, you just need to get comfortable of just acting upon little experience, little data. And that's not what lawyers are trained to do, frankly, right? I think the framework and the system you have within a law firm, within a legal department, what you are told is sort of the benchmark of good performance is an absolute high bar of accuracy and competency. Those necessarily look different in the startup game. I don't know what it means to be accurate as a startup founder. I don't know what it means to be competent as a startup founder. You've just got to get comfortable with the uncertainty. And so I would say that's the biggest thing that I continue to learn is getting comfortable with acting upon just the information or the ability that you need to move your company forward. I don't think that's something that you're used to necessarily as a lawyer.
Coming full circle, Ryan, the future of legal tech. We are living in turbulent and dynamic times. Artificial intelligence is propelling us leaps and bounds forward. What is your vision for the future of legal tech? How do you see this market changing over the coming 5-10 years? And what is Standard Draft's place in that scene?
Yeah. Let's take that one piece at a time. So the market just is changing. I do think there may be some commentators out there who will contend that the market isn't changing and perhaps AI is the new kind of the new hyped up thing. But I really do think our industry is going through a transformative time right now. Artificial intelligence, just by its nature, is going to mean something for an industry that has been dominated by words, right? So when you think about other professional services, accountants and others, and what they were able to do with spreadsheets and kind of their life work around numbers, one framework of generative artificial intelligence that I like that I've heard recently is in some ways it's a calculator for words. Having technological ability right now to go through cases to find that one argument that might be the winning argument for litigation, to go through a data room to find that contract clause that is going to be a hiccup for the M&A transaction you're negotiating, and then taking it to the next level, actually generating legal work. It's all happening right now. So I do think the technology is going to be transformative. I think people are seeing the signs of that. I, for one, don't even know if that's the right question to really ponder about, right? Because the legal industry, technology in and of itself is never the thing that spells dramatic change. We're such a people and process dominated industry that you've got to keep those things in mind. So I always think about, let's assume this technology is transformative. What does it enable? Like, what does tomorrow, and I mean that kind of generally, what does tomorrow look like as we're all using these kinds of tools? And that's where I wonder if we are applying this new technology, namely AI, in the right sorts of ways. And you can kind of parse out different areas of legal to kind of think through this, but coming back full circle earlier in the conversation, my whole vision around what I'm doing with my company, and I think this is true in some respects with what you're doing as well, is that there's more room for simplification. More things can be standardized. Some of this rote work that we do can be a lot more efficient. And so you might think, well, if we apply artificial intelligence to that, could that be the answer? And what I wonder is, well, no, does applying artificial intelligence to that actually just bury us deeper in this workflow that we have just assumed is the way that things should be done, but perhaps there's maybe a better way of doing things, and then can we leverage artificial intelligence to kind of find that better way of doing things, right? It's the same way in the early days of the internet. Clearly something there felt transformative. No one was really predicting social media, though. So despite the fact that you could take the cookbook that you had to go rent from a library and now you could go find those recipes online was transformative. And indeed it was, because we still use the internet in that way, that the perception of just how transformative it could be wasn't there in the early days. And right now we are in the early days. So as I see different kind of legal tech tools applying AI to our workflows, I constantly wonder, well, actually, how can we use AI to sort of advance us into a better and different way of doing? And as it relates to standard draft, my whole view is that the dance that we do around the drafting and negotiation of so many different kinds of contracts, but in particular high frequency routine contracts, should be a lot different. And if you're just applying AI to do that dance with new technology, where I as company A can use AI to produce my contract form, and then I send it to you, company B, and you're using AI to review it and mark it up, and now you're sending it back to me that just looks like the same game being played with new technology. I think there's a different sort of game we can play where we go to a platform that kind of represents this bridge between both sides to have accelerated contracting. And then can we look to AI to help us navigate that process in a fundamentally different way of entering into agreement with one another? That is what I'm trying to build with Standard Draft. We want to build this foundation of structured inputs, standardized content, and then use AI to leverage these more deterministic workflows with the generative aspects of AI that we might need to address those one-off situations, those particulars for any given deal. So that for me is where I think the most interesting products are going to be built in, call it the next half decade or so, is not just AI to find new, perhaps more efficient ways of doing the work the way we are used to doing the work, but can we use AI to just do the work differently at a more fundamental level?
Ryan, I relate to a lot of the things you touched upon in terms of, and I picked up this line from one of your articles on the impact of Gen AI on contract negotiation, paving the cow's path. Are we using AI to pave the cow's path, as in sort of cementing the way that things have been done, just doing them incrementally better, or fundamentally changing the way that we are making law happen? And I'm a bit hesitant to bet on the latter, right? Because law is just a very conservative, traditional profession. Based on my surveying of the transactional corporate legal tech space, I've noticed that the players that came into the market to try to fundamentally shift or alter, they use fancy words such as disrupt, revolutionize the industry, are the ones that have been marginalized, isolated, kicked out. I think the winning formula here is having legal tech, which will be easy to adopt because it seamlessly integrates with the way that lawyers already do things and helps them do it not even incrementally, but substantially better. And then once we have that adoption, we can gradually start changing the way that law is done on a very fundamental level to a very new way of doing things. I think it's going to start with changing our billing structures. And then once the billing structures change, the relationship between lawyer and client changes, as a result of which the floodgates open to new legal tech. But just my thinking on this problem, because I think we have to balance both. Improving the way things are done and then shooing our way into fundamentally new and different ways of doing things.
I totally hear you. I think, the reason why the space feels as dynamic and interesting as it does right now is because there are frankly no easy answers when it comes to things like this. I personally hear a version of, well, can we just find new software, perhaps AI-enabled tooling to take the way things are currently done and improve it, and then use that as a basis upon which we do more kind of profound things. I hear that, and to me, it feels like a version of the paving the cow paths, right? So the risk is when you take technology to more efficiently do the way you've done things before, it makes it much harder to then change that way. You are literally paving the cow path, right? And for the audience who maybe hasn't come across this before, like the background is the city of Boston. They literally paved the cow paths because that just seemed like the sensible thing to do. The cow paths were beaten in, let's pave over them. And so then when you went to, horse and carriage, maybe the downside of that wasn't too material. But then when the automobile came into the picture, and now you had all this infrastructure that was built around the cow paths, and you had these cow paths paved down, and now the automobiles are driving on it, well, now everyone's thinking, wait, why didn't we just build a logical street grid here? And it's because in the moments where you perhaps had those opportunities, you instead decided to continue to leverage the way things had been done, but with incremental new improvement. You put that pavement on the cow path, right? And all of this is kind of easy to hypothesize about. The act of trying to change behavior is very, very difficult.
True.
And so that's where I totally hear where you're coming from. You'll have no shot of, uprooting the cow paths and doing something else if you don't find your foot in the door to even get started, right? And navigating that is what is extremely challenging and frankly, very addicting too. Finding the right way to change, but giving yourself a shot of even having a chance to inspire that change.
And so when the cow's path has been paved, as in Boston, you then invest in the big dig to really help traffic move along and not create a gridlock.
Yeah, that's my company pivot right now. I'm leaving the legal tech space and I'm going into the big dig space.
Ryan, I was really looking forward to this conversation. I really enjoyed chatting with you. Wishing the best of luck to Standard Draft and hope to continue this conversation elsewhere.
Stepan, it was a pleasure. I think you and I have navigated a similar path to get us to where we are right now. We're going through some of the same challenges and joys, the ups and downs. So really enjoyed chatting with you, and I was happy we had this opportunity.
Ladies and gentlemen, my guest for today was Ryan Samii, founder of Standard Draft. You are very eloquent, Ryan. I've told this to you last time. I'm telling it to you again.